The U.S. Supreme Court has essentially said not right now when it comes to taking a case challenging AR-15 bans as Illinois cases are making their way through the courts. This is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Yesterday, we obviously had the order from the U.S. Supreme Court talking about the Snope case, and in particular how they are not going to take the Snope case at this moment. And we read through the order on the order list that was from Justice Kavanaugh yesterday, and it goes through and talks about how this is an issue and handguns were allowed via previous precedent. Does kind of hint at the semi-automatic handguns and rifles are distinct from automatic firearms such as M16s. That's an issue that was dealt with here in Illinois and the district court considerably. So it goes on to say that here we are. This court should and presumably will address the AR-15 issue soon in the next term or two. So what does that mean? That could be in next year, where we heard from State Rifle Association's Ed Sullivan several months ago about how this could be Illinois' case in particular, could be a 2026 case. But this case that the U.S. Supreme Court denied yesterday was the Maryland case. But looking at the dissent in that decision, you've got Justice Thomas dissenting from that. And I do want to read from this. It says the state of Maryland prohibits AR-15s. This petition presents the question whether this ban is consistent with the Second Amendment. The Fourth Circuit has held that it is, reasoning that AR-15s are not arms protected by the Second Amendment. Bianchi versus Brown. I would grant certs to review this surprising conclusion. Thomas goes on to say the Second Amendment guarantees the right of the people to keep and bear arms. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment's plain text covers conduct. Once a challenger makes that showing, the Constitution presumptively protects his conduct, and then the burden shifts to the government to demonstrate that its regulation is consistent with this nation's historical tradition of firearm regulation. If the government fails to make that showing, the restriction must be deemed unconstitutional. It is difficult to see how Maryland's categorical prohibition of AR-15s passes muster under this framework. To start, AR-15s are clearly arms under the Second Amendment plain text. In District of Columbia v. Heller, we held that terms arms and the context covers all weapons of offense or armor of defense. Anything that a man wears for his defense or takes into his hand or useth in wrath to cast or strike another. Thus, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Goes on to say because AR-15s are arms, the burden shifts to Maryland to show that the banning AR-15s is consistent with this nation's historical tradition of firearm regulation. But I am not aware of any historical regulation that could serve as a proper analog. Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons. It goes on to say, under this tradition, however, a weapon may not be banned unless it is both dangerous and unusual. So Thomas here is really laying out the arguments that are being made by Second Amendment supporters in these various court cases. Goes on to talk about tens of millions of Americans own AR-15s, and the overwhelming majority of them do so for lawful purposes, including self-defense and target shooting. Goes on to, essentially wrap things up and talk about the Fourth Circuit's case in Maryland and so on. Fourth Circuit's case aired, they said, in their challenges of these various precedents. You can read more of that by going to the U.S. Supreme Court's website and looking at the order list. But here it says, under the plain text, Thomas says, the Second Amendment, the challenger's only burden is to show that AR-15s are bearable arms. And again, a lot there, but one thing that when we reviewed the dominant opinion on this, whether or not to take the case out of Maryland, you had Justice Kavanaugh hint that indeed, you've got the cases that are coming through the various appeals court, and he even mentioned the Vermontes case in the appeals court. And this was a case out of Chicago challenging Cook County's ban on semi-automatic firearms. And there yesterday was an order in that case. Just taking a look at the docket here in the Vermontes case v. Cook County et al. This order essentially says that the judgment in the district court is affirmed with costs in accordance with the decision of this court entered on this date. So this is yesterday. The appeals court in the Vermontes case affirming the lower court. So you've got that order issued yesterday after you had the case argued back in November. So after the U.S. Supreme Court said, hey, we're not taking the Maryland case, we're waiting on outcomes from, say, cases like Vermontes in Cook County. So now we have finality in that in the appeals court, final judgment per non-presidential disposition, saying that the lower court is affirmed. And Vermontes was the appellate there, the one appealing a decision in the district court, so it went against him. So that's obviously fresh, that's new, and we'll see if the Vermontes case goes all the way up to the U.S. Supreme Court next. It's now able to. So is that going to be a case that challenges Illinois' gun and magazine ban that gets to the U.S. Supreme Court first? Very interesting to see that. But where are we at on the Barnett case? That's the very large case that happened with the district court having a 4-day bench trial in the Southern District of Illinois, where they ultimately had an outcome in favor of the plaintiffs in the case, the people suing the state of Illinois. You had the district judge say that they are unconstitutional laws after going through considerable testimony on the difference between semi-automatic rifles and full auto rifles in the military, a whole bunch of other arguments made back and forth. So I'm trying to find the latest in the Barnett case, as we did have filings go back and forth, but those cases we're still waiting on an argument date, an oral argument date to be given. So the appeals court's still sitting on that. I'm trying to get here. Oh, got to go to the second page of my my list of all the litigation I'm following here. So here's the Barnett case. All right, so we'll get to the latest if there are any other filings here. I'm looking at the court dockets in the appeals court. All the way down, 7-2, file order. The Supreme Court is denying the petition of writ. Oh, that was last year. Wow, and that was July 2nd of last year, if you remember that. So we gotta get updated here on where we're at on the latest in the Barnett case. That was a different appeals court case, and I'm still not going to the second page. Here we go, second page. We're doing this live. That's what's good about this show. Not on the second page. Come on now. Here we go. Pull that up. Is this the right one? Yes, it is. So, yeah, we don't have any updates. I mean, the last thing we talked about was some amicus briefs that were filed, and you've got another one that was filed just last week from the Brady Center. It's not available yet, but obviously we'll see what we can get on that. So we're still waiting on all of the briefs to be filed in the Barnett case. There hasn't even been a oral argument in the Barnett case. But as we just showed you, the Vermontes case challenging Cook County and the state of Illinois, that a district judge ruled against Vermontes. The appeals court heard it in November, and now you've got the order from the appeals court essentially siding with the district court's decision. So Vermontes could very well go to the U.S. Supreme Court next, while the Barnett case we're still waiting on. And the Barnett case has that big record of, the difference between consumer semi-automatic rifles and military grade rifles. All right, so that's where we're at in all the litigation, right? The U.S. Supreme Court denying taking up the Maryland gun ban case, saying there are other cases in appeals courts, including the Veramontes case out of Cook County in Chicago that could come next. And the Veramontes case decided yesterday, siding with the district court's decision that Veramontes is wrong, that the law can be upheld. So that case obviously ripe for the U.S. Supreme Court. The Barnett case from the Southern District, where a district judge found it unconstitutional, in the appeals court, still being briefed. No oral arguments scheduled yet. So that's the latest, at least, when it comes to the litigation. But what about the laws that passed the General Assembly before they adjourned spring session? Obviously, Senate Bill 8, we've talked extensively about that. That's the storage of firearms law. The safe gun storage would require you to lock up your firearms if there's anybody in the home or in the premise that is considered a prohibited person. There's also lost and stolen requirements for you to report within 48 hours. If you don't do that, after several times, you could be held liable and have your FOID card revoked. Well, another measure they passed before the end of session out of both chambers was House Bill 850. This would bring about a variety of changes. It would allow for state police to do certain kinds of tracking for firearms data to help inform them about crime statistics and such. But it would also allow for the Department of Human Services to report Illinois State Police on people who they consider clear and present dangers, which could lead to their FOID card being revoked, suspended, or denied. Well, another measure in House Bill 850 would also allow for the FOID card review board to have a process to which those who had their FOID card, their firearm owner ID card, revoked, suspended, or denied, those individuals could appeal that and get information about why they were denied, why it was revoked and such. And then they could also go to court and try to have their rights restored. Here's Julie Morrison, a Democrat senator from Lake Forest, talking about how the bill is good for public safety. And let's go over here. Fire away.
Improves the FOID card process, providing more due process, more access to records.
So more access to records. You had state senator not too happy about this idea. Here is...
This is a lack of due process.
Neil Anderson.
This is a lack of due process. This is giving state police the ability to take a constitutional right away and then the gun owner having to petition the court to get his right back.
So clearly, Republicans don't see this as due process. Democrats say it improves due process. It actually gives people the ability to appeal. But Republicans in the Second Amendment space say it's not due process because it's an administrative thing that stripped somebody of their rights and without a hearing. And you need a hearing in order to strip somebody of their rights, a hearing that of which the accused is able to face their accuser before their rights are stripped. This is an after-the-fact issue, and it's not really due process. Julie Morrison talking more about what she says is good in this bill that she advanced.
It's critical to preserve the ISP's ability to take immediate administrative action, including the revocation of FOID cards when necessary, while ensuring a transparent process for reviewing and correcting erroneous determinations.
So a lot of back and forth there. And there's another element we didn't talk about that Republican State Senator Terry Bryant highlighted, and it gives immunity to the FOID card review board members to not be held civilly or criminally liable for any decisions they make that could impact somebody's FOID card status.
I just want to be sure that everyone understands before they vote on this. This prohibits ISP and the FOID card review board from being held liable for damages in any civil action arising from the alleged wrongful or improper granting, denying, renewing, revoking, suspending, or failing to grant, deny, renew, revoke, or suspend a firearm owner's identification card. With this bill, we're taking away the ability to have civil litigation against the review board, the FOID review board, and against ISP on all of these FOID issues.
So that did pass both chambers. That's kind of a grab bag of where we're at in the Second Amendment space in the state of Illinois and across the country. Again, brief recap. U.S. Supreme Court denies taking the challenge against Maryland's gun ban, citing their other cases, including a case out of Cook County challenging gun bans, the Vermontes case. Today, we find out that the Vermontes case is now done in the appeals courts, and that can go to the U.S. Supreme Court, while the state of Illinois continues to pass more gun restrictions. It is Illinois in Focus Daily. I'm Greg Bishop. Appreciate you guys being here each and every weekday morning. Don't forget, you can join the live chats when we go live every weekday morning at 8 o'clock. Program note, I'm off Friday. Like, subscribe, hit that notification bell, get the headlines in your inbox, thecentersquare.com, and get the podcast where you get podcasts. Illinois in Focus.